The contractions started at 4:17 in the afternoon, and by the time Nora Callum understood what was happening, her husband's truck was already gone from the driveway. She would learn later that Doyle had driven straight to the county seat. Not to the hospital where she was calling a neighbor because she couldn't reach him. Not to his mother's house. Not to the feed store. Not anywhere she would have thought to look. He drove to the office of a man named Gerald Phelps, a notary whose name appeared on documents in 3 counties and who was known, if you knew where to ask, for his willingness to witness signatures without asking too many questions about them. Doyle had been carrying the paperwork in his truck for 6 days. He had been waiting for a moment when Nora would not be watching. He chose the moment she was in labor with their daughter. If you're enjoying this story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. The farm had been in Nora's family for 61 years. Her grandmother, Ruth Callum, had bought it in 1961 with money she'd earned from 20 years of taking in laundry and mending clothes and doing the books for 3 different businesses in town. All of it saved in a coffee can she kept behind a loose brick in the kitchen wall because she didn't trust banks the way her own mother hadn't trusted them after 1929. Ruth had bought 12 acres and a house and a barn and 2 outbuildings at the western edge of Harlan County, Kentucky, and she had put the deed in her own name, which was not a simple thing for a woman to do in 1961, and she had farmed it and kept it and raised her daughter there, and her daughter had raised Nora there, and Nora had grown up understanding that the land was not just land. It was the proof of something. It was 60 years of a woman's work made solid and permanent. Nora's mother had passed the spring before Nora turned 30. It was a swift thing, a stroke, the kind that doesn't give you time to prepare, and when it was done there was the farm, and there was grief, and there was Doyle, who had been her husband for 4 years by then. Doyle Mabry was a man who could charm a room and couldn't sit still in one for more than 20 minutes. And Nora had married him knowing both of those things because she was 26 and he was handsome, and because grief makes a person reach for warmth wherever it comes from. She had believed, for a while, that she could build a life with him on her grandmother's land. The signs had been there before she chose to read them. Doyle's habit of referring to the farm as his farm when he talked to other men. His irritation when Nora made decisions about the fields or the fencing without asking him first. The way he would talk at the kitchen table about what they could get for the back acreage if they sold it to the Hensley family next door, or what the timber on the ridge was probably worth, and the way his eyes moved over everything like a man calculating. Nora had told herself it was ambition. She had told herself that was not the same thing as threat. She was 32 when the pregnancy test came back positive. She was tired and happy and scared in the specific way of a woman who has wanted something for years and doesn't quite trust that she's allowed to have it. She told Doyle over dinner. He went quiet in a way she had learned to watch, the quiet that wasn't peace but calculation. And then he said that was good news and got up and went outside, and she heard his truck start, and it was 2 hours before he came back. She didn't know what he'd been doing in those 2 hours. Not then. The baby came 7 months later on a Tuesday in November. Nora's neighbor Patsy drove her to the hospital because Doyle didn't answer his phone, and Nora had their daughter, Wren, in a room that smelled of antiseptic, and outside the window the last of the autumn leaves were coming down, and she held the baby and thought about her grandmother and cried, and it was the best and worst day of her life so far. Doyle arrived at the hospital at 9 that evening. He had been drinking, not heavily, but enough that she could smell it, and he held Wren for 11 minutes, and then put her back, and said he was going to sleep at his buddy Carl's place because the hospital chairs killed his back. He kissed Nora on the forehead and left. And somewhere between the hospital parking lot and Carl's house, or maybe before any of that, he had already done what he came to the county seat to do. Nora found out 43 days later. She was home from the hospital, Wren sleeping in the bassinet in the corner of the bedroom, and she was going through the filing cabinet in the room her mother had used as an office because the property tax notice had come in the mail and she needed the parcel number, and she couldn't remember where her mother had kept the deed documents. She went through the top drawer and then the second, and she was reaching into the back of the third when her hand found a folder that felt wrong. Too thin. She pulled it out. It was not the deed. It was a copy of a transfer agreement. A quitclaim document with her name on it as grantor and a holding company called Blue Ridge Property Partners, LLC, as grantee. The transfer was dated the day Wren was born. The notary seal belonged to Gerald Phelps. And the signature on the grantor line, the line that bore her name, was not her signature. It was not even a good imitation. Doyle had not tried very hard because Doyle had not expected anyone to look closely, and in his experience, in the experience of a man like Doyle, people who were told something was done tended to believe it was done and stop asking questions. Nora sat on the floor of her mother's office with the baby monitor clipped to her waistband and the document in her hands, and she read it 3 times. Then she read it a 3rd time, slowly, the way you read something you need to understand completely before you respond to it. The transfer purported to sign over the entire 12-acre parcel, the house, the barn, and both outbuildings, for a consideration of $1, to a company she had never heard of, on a day she had been giving birth to their daughter. She called Doyle's cell phone. It rang 4 times and went to voicemail. She called again. Same. She put the phone down, and she sat in the quiet of her mother's office, and she looked at the document, and she understood, with the cold clarity that comes when you have finally seen something you had been half seeing for years, that her husband had sold her grandmother's farm out from under her while she was in labor. And he had done it to a company that almost certainly existed for that single purpose, and that he almost certainly had some arrangement with, and that the whole thing had been planned at some point during the 7 months she had been carrying his child. She did not cry. She had cried enough in that hospital room. Good tears, honest ones, holding Wren. She was not going to spend tears on this. What she did instead was start looking. Nora had grown up on that farm. She had helped her grandmother mend fences and plant kitchen gardens, and she had spent her childhood in every corner of those 12 acres. She knew the land the way you know a place that shaped you, not just its surface, but its particulars. The way the light hit the ridge at 4 in the afternoon. The way the barn's south wall sweated in August. The smell of the root cellar in October. She also knew that her grandmother Ruth had been a woman who kept things. Not out of sentimentality, but out of principle. Ruth Callum had grown up in a family that lost things because they didn't have proof of them, and she had spent her adult life making sure that whatever she owned, she could document. There were 2 filing cabinets in the office, a small lockbox in the bedroom closet that Nora's mother had kept after Ruth died, and somewhere, if she remembered right, a metal deed box that Ruth had kept in the cellar under the basement stairs. A place she had called the cold room because the temperature stayed, even down there, and paper kept well in even temperatures. Nora bundled Wren into the baby carrier and went down. She hadn't been in the cellar since the summer. The stairs were steep, and she went carefully, one hand on the railing. The cold room was a low space at the back, partitioned off from the rest of the cellar by a wall of old fieldstone that her grandmother's father had laid sometime in the 1940s. There was a narrow wooden door in the wall, swelled slightly with age, and behind it the temperature dropped another 5 degrees, and the air smelled of dry stone and the particular mineral coolness of deep earth. Nora had been in here dozens of times as a child. She used to hide in it during summer hide-and-seek because it was small enough to feel like a secret and no one else wanted to go in the dark. She switched on her phone's flashlight. The shelves along the wall held mason jars of things her mother had put up, some of them years old by now, and in the back corner, half behind a stack of empty wooden crates, she found what she was looking for. The deed box was olive green metal, the paint worn to silver at the corners, with a simple latch and a small padlock that she remembered her grandmother keeping locked. She didn't know the combination. She set it on the floor and crouched over it with the baby warm against her chest, and she looked at the padlock, a 3-digit combination lock, the old kind. She tried 1961, the year of the purchase, but that was 4 digits. She tried 161, the first 3 of the year. Nothing. She tried Ruth's birthday, month and day. The lock clicked open. The box was full, not of a single document, but of a careful archive. Her grandmother had kept everything in here, organized in the way of a woman who had once lost paperwork she couldn't replace and had never allowed that to happen again. There were folders, each one labeled in Ruth's small, precise handwriting, and Nora went through them one by one with the flashlight in her mouth and the baby sleeping against her chest. The original deed was in the first folder, the one dated August of 1961, recorded in the Harlan County Clerk's office, bearing the raised seal of the Commonwealth of Kentucky and the recorder's stamp and the name of the previous owner and the name of the grantee, Ruth Elaine Callum, a single woman, as sole owner in fee simple of the property, described as Lot 7 of the Whitaker Survey, 12 acres and 3/10, together with all improvements thereon. In Harlan County, Kentucky, Nora held the deed in her hands. She had seen it as a child, but she had not understood then what it meant to hold it. She understood now. This was the thing that was real. The quitclaim upstairs was a fraud on a single page. This was 60 years of proof in her hands, recorded by the county, stamped and sealed, the original instrument of her grandmother's ownership. But she kept looking, because she had learned, in the last hour, not to stop looking. The second folder was labeled simply R.E.C. Personal Notes, and inside were pages in her grandmother's handwriting, not legal documents, but records. Ruth had kept notes on every transaction involving the property going back to the day she bought it. Every tax payment, every boundary survey, every improvement, every conversation with the county assessor. It was the record of a woman who understood that ownership without documentation was just a claim, and claims could be taken away, but documentation was harder to undo. The third folder stopped her. It was labeled Codicil, 1987, and inside was a handwritten legal document, dated November of 1987, witnessed by two signatures Nora didn't recognize and notarized by an Eleanor Watts, a name she had never heard. The document was written in the formal language of legal instruments, but in Ruth's own hand. Nora read it twice in the cold room under the beam of her phone's light, the baby breathing steadily against her chest. Her grandmother had written a codicil to her will in 1987, 3 years after Nora's mother had married. The codicil modified the terms of the original bequest. The farm, Ruth had written, was to pass to her daughter Loretta as life tenancy only, not in fee simple. Upon Loretta's death, the property was to pass in fee simple, outright and free of any encumbrance, to Loretta's daughters, to be held jointly, and in the event of only one surviving daughter, to that daughter alone. The codicil specified, in language that Nora read a third time because she needed to be certain of it, that the property could not be conveyed, encumbered, or transferred by any spouse of any beneficiary, that the interest was held by blood descent only, and that any purported conveyance by a spouse without the explicit written and notarized consent of the blood heir would be void and of no effect. Nora sat on the cold floor of the root cellar for a long time. Her grandmother had written this codicil in 1987. Nora had not yet been born. Her grandmother could not have known about Doyle Mabry. She could not have known that 26 years later her granddaughter would marry a man who would try to sign the farm away while she was in a delivery room. Ruth Callum had simply known, from 60 years of living as a woman who owned things in a world that sometimes disputed women's right to own them, that protection had to be built into the document before you needed it. That the time to close a door was before someone tried to walk through it. If you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one. She carried the box upstairs. She laid all 3 documents on the kitchen table. The original 1961 deed, the 1987 codicil, and the fraudulent quitclaim. She put them in a row and she looked at them together and she felt, underneath the cold anger that had been in her chest since the filing cabinet, something else. Something her grandmother would have recognized. Certainty. There was a woman in town named Frances Drummond who had practiced property law for 30 years out of an office on Main Street above the hardware store. Nora had met her once at her mother's funeral, a tall woman with silver hair and a handshake that meant something. She called her at 7:30 the next morning. Frances picked up on the second ring. Nora told her the short version. Fraud. Forged signature. Day of delivery. She said the word codicil and heard Frances go quiet in the particular way of a lawyer who has just understood that a case is more interesting than it appeared. Can you come in this morning? Frances said. I have a 6-week-old, Nora said. Bring her, Frances said. Nora was in Frances Drummond's office by 9. Wren in the carrier, the deed box under her arm. Frances read all 3 documents in order without speaking. Then she read the codicil again. Then she set it down and looked at Nora over her glasses. Your grandmother was a careful woman, Frances said. She was, Nora said. Frances turned the codicil over in her hands. This was recorded? Filed with the county clerk in November of 1987, Nora said. I checked the recording number on my way in. It's in the system. Then it's part of the chain of title, Frances said. Which means any title search on this property would have turned it up. She paused. The company that received the purported quitclaim. If they did a title search before accepting the conveyance, they would have found this codicil. It restricts spousal conveyance explicitly. Any competent title examiner would have flagged it. So either they didn't search, Nora said, or they knew and believed the codicil could be argued around, Frances said, or they didn't care because they assumed no one would look. She set the codicil down. Here is what the law says, she said. A forged instrument of conveyance is void ab initio. That means void from the beginning, as if it never existed. It conveys nothing. If your signature was forged, and from what you've described there's a question about whether the notary actually witnessed you sign anything, then Blue Ridge Property Partners LLC received nothing. The deed to this property never moved. But they may have filed it, Nora said. Filing a void instrument doesn't make it valid, Frances said. It creates a cloud on the title. We'll need to clear it. But clearing it is a legal proceeding, not a negotiation. We go to court. We present the original chain of title, the codicil, and the evidence of fraud, and we ask the court to quiet the title in your name. Given the codicil's explicit language and the clear evidence that you were in a hospital on the date of the purported signing, I don't anticipate that being a difficult argument to make. She folded her hands on the desk. What about Doyle? Nora said. Frances looked at her steadily. A forged deed is a felony, she said. That's a matter for the Commonwealth's attorney. I can make a referral if you want me to, but that's your decision. What I'm going to do first is file a lease pendens on the property today, which puts the world on notice that there's a legal dispute over the title, and that will stop any further conveyance while the quiet title action proceeds. No one can sell what you have a pending claim on. Nora looked at the codicil on the desk. Her grandmother's handwriting. The date, 1987. She thought about Ruth Callum in 1961, walking into the county clerk's office with 60 years of saved money and putting her name on a deed in a county where a woman doing that was not a simple thing. She thought about Ruth in 1987, sitting down to write a document that would protect something she had built from the people who might one day try to take it. People she couldn't name yet because they didn't exist yet, but whom she understood would exist because she had lived long enough to understand how these things went. She thought about Wren asleep in the carrier against her chest, 6 weeks old, knowing nothing yet of property or fraud or the weight of a piece of paper. File everything, Nora said. Frances Drummond was efficient in the way of someone who has done the same work for 30 years and does not waste motion. The lease pendens was filed that afternoon. The quiet title action followed within the week, naming Blue Ridge Property Partners LLC as defendant and setting out the chain of title from Ruth Callum's original 1961 purchase through the 1987 codicil through Nora's inheritance and ending with the forged quitclaim and its legal nullity. Frances attached certified copies of every document from the deed box. She attached the hospital records placing Nora at Harlan County Medical Center on the date of the purported signing. She attached a statement from Patsy, Nora's neighbor, confirming that she had driven Nora to the hospital and had been present for most of the day. Then Frances did one more thing. She wrote a letter to Gerald Phelps. It was a short letter. It noted that a notary seal had been affixed to a document bearing a forged signature and raised the question of whether the notary had been present for the signing as required by law or whether the seal had been provided without witnessing the actual execution of the instrument. It asked Mr. Phelps to consider his exposure and noted that the matter had been referred to the Commonwealth's attorney's office. Gerald Phelps called Frances within 48 hours. He had, it turned out, a good deal to say. He had met with Doyle Mabry twice. The first time, Doyle had asked questions about the process. The second time, he had presented the document and told Gerald that his wife was unavailable due to a medical situation but had signed the document previously and that Gerald's job was simply to affix the seal for the convenience of the parties. Gerald had believed this, or had chosen to believe it, because Doyle had paid him in cash and because the question was not one Gerald had wanted to examine closely. He was willing to provide a sworn statement to that effect. The Commonwealth's Attorney's Office opened an investigation into Doyle Mabry 3 weeks after Nora walked into Frances Drummond's office. Blue Ridge Property Partners, LLC, when Frances's process server went looking for them, turned out to be a shell company registered to a post office box in a town 60 miles away. The registered agent was a man named Carl Beaumont, who was Doyle's buddy Carl, the one Doyle claimed to be sleeping at on the night Wren was born. The company had no assets, no employees, no operations. It had been formed 11 days before Wren's due date. Its sole apparent purpose was to serve as the grantee in a fraudulent transfer that Doyle had intended to use as the first step in a sale to a development company that had, Francis discovered during discovery, been in contact with Doyle about the timber rights on the ridge for at least 8 months before the transfer. A timber company out of Tennessee had been corresponding with Doyle about the ridge acreage. The ridge held mature hardwood, oak and walnut and poplar, the kind that commanded serious money in the specialty lumber market. Doyle had told them he was in the process of acquiring clear title and would be in touch. He had been telling them this since the spring, since the pregnancy, since Nora had started showing and Doyle had started calculating. Francis laid all of this out for Nora at a meeting in early February. Wren propped against Nora's shoulder, and Nora sat and listened to the shape of it, and felt the cold anger harden into something that was not quite anger anymore. It was more like grief for the version of her life she had believed she was building, and underneath the grief, something clearer. The understanding that she had not been wrong to love the farm. She had been wrong about Doyle. Those were not the same mistake. The quiet title hearing was set for March. In the weeks leading up to it, Nora did what her grandmother had done. She kept records. She walked every acre and photographed the boundary lines and the improvements. She had the deed box reorganized and the documents digitized. She learned the parcel number and the section and township and range from the original survey description, the specific language of the legal description as it appeared in every recorded instrument going back to 1961, the chain of title clear and unbroken from Ruth Callum to her daughter Loretta to Nora, each transfer documented, each recording stamped. She went to the county clerk's office herself. The clerk, a woman named Vera who had worked in that office for 22 years, pulled the title history at Nora's request and went through it with her. She confirmed that the 1987 codicil was recorded, that the recording was valid, that the chain of title was intact, and that the codicil's restriction on spousal conveyance was explicit and of record. She looked at the quitclaim Doyle had filed. She looked at the codicil. She looked at Nora. "Your grandmother knew what she was doing," she said. "She did," Nora said. Vera made a copy of the codicil for her files and handed Nora back the original. The night before the hearing, Nora sat at the kitchen table where she had found the transfer document 43 days after Wren's birth, the same table her mother had sat at and her grandmother before her. Wren was in the bassinet in the living room, making the small sounds she made when she was almost but not quite asleep. The deed box was open on the table. Nora had been going through it again, not because she needed to, but because she wanted to be close to it. She found something she hadn't noticed before. In the back of the folder labeled Personal Notes, behind the records of property taxes and boundary surveys, were 2 pages she hadn't read. They were not records. They were a letter, dated the same month as the codicil, November 1987, and addressed to no one by name. Her grandmother had written it to whoever might one day need to read it. Ruth had written that she was changing the terms of the bequest because she had watched, over the course of her 60 years, what happened to women's property when it passed through marriages. She had watched her own mother lose the house she'd grown up in because her father had debts and the house was in his name. She had watched a cousin lose her inheritance because her husband had signed it away during a separation. She had watched the pattern repeat enough times to understand it was not accident or bad luck. It was structure. It was the way things were arranged when women's property was treated as family property and family property was managed by the men in the family. She had not been able to change the structure, but she could build a wall around her own acre of it. She had written, and this was the line that made Nora put the letter down and sit still for a long moment, that she hoped whoever read this would not need it, that she hoped the codicil would sit in its folder for 100 years and never be necessary, but that she had learned the hard way that the things you hoped you'd never need were exactly the things you made sure you had. Be careful, she had written, but more than careful, be documented. Paper outlasts everything. Nora folded the letter and put it back in the folder. She closed the box. She went to check on Wren, who had fallen asleep with her fist against her cheek, and she stood over the bassinet in the quiet of the house her grandmother had bought and thought about the long chain of women who had sat in these rooms. What it had taken to hold the land. What it had cost. What her grandmother had understood, at some point before Nora was born, about the kind of world the land existed in, and how to protect it from that world. She thought about what she would tell Wren, when Wren was old enough to understand. About the deed box in the cold room. About the codicil. About the woman who had written it in 1987 without knowing her granddaughter's name. She thought she would tell Wren that the best thing her great-grandmother had left her was not the land. It was the knowledge that protection had to be built before you needed it, that a woman who owned something had to own the proof of it too, and that a piece of paper in the right drawer, filed with the right office, kept safe in a box that stayed where the temperature was even, was sometimes the difference between everything and nothing. The quiet title hearing lasted 2 hours. Frances argued clearly and without excess. She presented the chain of title from the 1961 deed through the 1987 codicil. She presented the hospital records. She presented Gerald Phelps's sworn statement. She presented the evidence that Blue Ridge Property Partners LLC had no independent existence apart from Doyle Mabry and Carl Beaumont. She presented the correspondence between Doyle and the Tennessee Timber Company. The attorney for Blue Ridge Property Partners did not appear. The registered agent had not responded to service, and the company, such as it was, had no counsel. The judge, a man named Honorable Thomas Reese who had been on that bench for 16 years, read through all of it with the attention of someone who intended to understand what he was ruling on, and then he asked Frances one question. The codicil's restriction, he said. The language on spousal conveyance. Was this recorded at the time the marriage took place? 6 years prior to the marriage, Frances said. It was of record and would have appeared in any title examination. Judge Reese looked at the quitclaim. He looked at the codicil. He looked at the hospital records. The court finds, he said, that the instrument of conveyance dated the 15th of November is void ab initio. The signature of the grantor was not authentic. The notary's certification was obtained through misrepresentation. The conveyance is further barred by the recorded codicil of November 1987, which explicitly prohibits spousal conveyance without the written consent of the blood heir, which consent was never obtained. The cloud on the title is removed. Title is quieted in the plaintiff, Nora Ruth Callum, in fee simple absolute. He looked at Frances. I'd like a certified copy of this order for the county recorder's office. He looked at Nora. You have your grandmother to thank for the codicil. I know, Nora said. I know I do. Word moved through Harlan County the way word does in a small place, which is to say it moved before the ink was dry. Nora did not tell anyone herself. She didn't have to. Frances's paralegal knew Vera at the county clerk's office, and Vera mentioned it to the woman who ran the hardware store, and by the end of the week most of the county had heard a version of the story that was accurate in its main features even if some of the details had shifted in the telling. People's responses sorted themselves into categories. There were the people who had known Ruth Callum and who said yes. That sounds like Ruth. She was that kind of woman, the kind who planned for the worst and hoped for the best and kept her papers in order. There were the people who had known Doyle and who said they always thought there was something off about him, but out loud said only that they hoped Nora and the baby were doing all right. There were the people who shook their heads at the whole thing and said they didn't understand how a man could do that to the mother of his child. And these people were not wrong, but they were also not the people Nora spent time thinking about. The one response that mattered came from Patsy, her neighbor, who brought a casserole and sat at the kitchen table and said simply, "Your grandmother would be proud of you. Not because you won the court case, because you went down to the cellar and looked." Doyle entered a guilty plea to deed fraud in May. He received a suspended sentence and 3 years of probation and was ordered to pay Frances Drummond's legal fees, which he did not pay on schedule and which Nora eventually had to collect through a judgment. Carl Beaumont received a lesser charge for his role in the shell company. Gerald Phelps surrendered his notary commission. The Tennessee Timber Company, once it became clear that clear title would not be forthcoming from Doyle Mabry, stopped returning his calls. Nora filed for divorce in June. It was not complicated because there was nothing to divide. The farm was hers. It had always been hers. The court had said so. Her grandmother had said so in 1987. Ruth Callum had said so in 1961, the day she walked into the county clerk's office and put her name on a deed. In the late summer, when Wren was 8 months old and had recently discovered that she could pull herself to standing using the edge of the kitchen table, Nora went back down to the cold room with a flashlight and the deed box. She had one thing to add to it. A certified copy of Judge Reese's quiet title order, which she slid into a new folder she labeled Quiet Title, March, with the year. She wrote in her own handwriting below the label, one line, the same line her grandmother had written in the personal notes folder. Paper outlasts everything. She put the box back on the shelf, behind the empty crates, in the corner where the temperature stayed even. Then she went back upstairs and picked up her daughter and walked out onto the porch where the evening light was coming long and gold across the 12 acres that belonged to them. The house and the barn and the outbuildings and the ridge with its timber and the field below it and all the fence lines that she had walked and photographed and knew by heart. All of it exactly as her grandmother had left it. Exactly as her mother had kept it. Exactly as Nora intended to hand it to Wren when the time came. With clear title and a deed box in the cold room and a folder for every document that mattered. Wren put her fist against Nora's cheek the way she had learned to do when she wanted to be held closer. Nora held her closer. Someday she would tell her. About Ruth Callum in 1961 and the coffee can behind the loose brick. About the codicil written before Nora was born. About the November afternoon when Nora had gone down the cellar stairs with a flashlight and found the box and found inside it everything she needed. She would tell her that the women in their family had understood something that took the world longer to learn. That what you own, you have to prove. That the proof has to live somewhere safe and stay there and be found when you need it. That a woman who keeps her papers is a woman who keeps her land. She would tell her, when Wren was old enough to stand in the cold room herself and understand what she was looking at, that the deed box was not just a box of documents. It was an inheritance, not of money, of knowledge. The knowledge that the land was theirs, had always been theirs, and that Ruth Callum had made sure of it long before anyone tried to say otherwise. That was the gift, not the 12 acres, though Nora was grateful for every foot of them. The gift was the woman who had understood that you could not love a thing and assume it was safe. You had to build its safety yourself, document by document, filing by filing, one careful piece of paper at a time. Ruth Callum had done that. She had done it for a granddaughter she hadn't yet met, in a future she couldn't see, against a threat she couldn't name. She had done it because she was the kind of woman who planned for the worst and kept her papers in order, and because she had learned from her own mother's losses that the things you hoped you'd never need were exactly the things you made sure you had. Nora stood on the porch until the light was nearly gone and the ridge was just a dark line against the last of the sky. Wren had fallen asleep against her shoulder, the way she always did in the evening when the air went cool. The farm was quiet. The barn, the outbuildings, the fence line she'd walked in November with her phone and her flashlight, all of it holding still in the dusk. Below the porch, where her grandmother had put in a kitchen garden 60 years ago, and her mother had kept it going and Nora had replanted it that spring, the last of the tomatoes were still on the vine, red and heavy in the low light. All of it hers. All of it documented. All of it safe. Her grandmother's work, still standing. Thank you so much for watching until the end. If you love this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.